5 seconds to go. Start. Learned Counsel further submits that the learned trial judge was at least required to examine the existence of prima facie material regarding participation of the appellant in the commission of crime or existence of grave suspicion against him, and when there is no prima facie material of suspicion, what to say of grave suspicion, the charge cannot be framed, and accordingly the counsel submitted that the charge framed against the appellant by the learned trial judge is not sustainable, as there is no evidence against him, and prayed for its discharge. Learned counsel for the respondent, on the other hand, submitted that there is sufficient evidence against the appellant to suspect commission of crime, and only after examining the charge sheet and other material available on record, the charges were framed by the learned trial judge, and in the given facts and circumstances, there is no error committed by either the trial judge by framing of charge or the High Court in dismissing the revision preferred by the appellant under the order impugned. We have heard learned counsel for the parties, and with their assistance perused the material available on record. Before we proceed to examine the matter on merits any further, it will be apposite to take note of the legal principles applicable seeking discharge, for which we may refer to a judgment of this court in P. Vijayan versus State of Kerala, and another which has been further reiterated by this court in the recent judgment in M.E. versus Central Bureau of Investigation, Bengaluru, and discerned the following principles. If two views are possible and one of them gives rise to suspicion only as distinguished from grave suspicion, the trial judge would be empowered to discharge the accused. The trial judge is not a mere post office to frame the charge at the instance of the prosecution. The judge has merely to sift the evidence in order to find out whether or not there is sufficient ground for proceeding. Evidence would consist of the statements recorded by the police or the documents produced before the court. If the evidence which the prosecutor proposes to adduce to prove the guilt of the accused, even if fully accepted before it is challenged in cross-examination or rebutted by the defense evidence, if any, cannot show that the accused committed offence, then there will be no sufficient ground for proceeding with the trial. It is open to the accused to explain away the materials giving rise to the grave suspicion. The court has to consider the broad probabilities, the total effect of the evidence and the documents produced before the court, any basic infirmities appearing in the case, and so on. This, however, would not entitle the court to make a roving inquiry into the pros and cons. At the time of framing of the charges, the probative value of the material on record cannot be gone into, and the material brought on record by the prosecution has to be accepted as true. Stop.